So good morning to everybody. It looks like we have about 20 folks here online with us this morning. So thank you for coming. As I said, this will be recorded. So if you're watching it later, then I suppose if it's not morning, then good evening or good afternoon. But thank you to everybody who joined us today. I appreciate the opportunity to talk with you a little bit about some of the recent changes or updates in the Missouri legislation. So I think we've got about 35 to 45 minutes of material to go through. Hopefully it will be interesting and informative to everybody. I'm going to see if I can share my screen here. And we will get started. Okay, so everybody should be able to hopefully see the PowerPoint at this stage. If you can't, let me know. But today we're going to talk about some legislative updates from Missouri. So specifically, we're going to talk about Missouri updates from the General Assembly. We're not going to talk about any of the exciting or perhaps sometimes scary things that are happening on the federal level in DC. This is just Missouri. I would also point out that all the bills that we're going to talk about today, so House Bill 225 and Senate Bill 71 and several others, all have been passed on to the governor. So they've passed the General Assembly. They're waiting on the governor's desk. And it is my understanding that he intends to sign all of those bills, but of course his signature is the last step in the process. And so until he signs them for sure, they won't be guaranteed to go into law. If he signs them, which he has 45 days to do from the date that he received them, which I think was May 30th for all of them. So sometime late in June or mid-July, I anticipate that all of these will be signed. Once that's done, then they will go into effect on August 28th, which is the date set by the Missouri Constitution. So some of the changes that we want to take a look at today, just kind of the highlights. There are several changes for taxing authorities, so tax provisions and audit provisions that we want to take a look at. And then also there's a cardiac response plan for school districts I want to mention briefly. We'll look at the training for ambulance districts. There are some new requirements both for the board and for the ambulance administrator that we want to talk about. And then perhaps maybe the most exciting for everybody is this Public Safety Recruitment and Retention Act that we want to go over that will provide tuition payments for full-time employees in public safety and their dependents. So we want to look a little bit kind of the details about how that will work and what it takes to qualify and how that may help us going forward in attracting more people into public safety. There are also some pretty significant changes to allow some corrective action by the Bureau of EMS. And so that the statute uses the word corrective action. I really think this is intended as an opportunity for the Bureau to assist districts that maybe have some concerns that may be struggling in one way or another. And so a lot of this is really more about promoting dialogue between those agencies and their neighboring partners and their community leaders, just to make sure that all ambulance services are succeeding in the state of Missouri. And then finally, we're going to look at just some other general changes, not general because they're not important, just because they didn't really fall in any of my other categories, but there were some changes to the line of duty death benefit, and there's a new crime for interference of a first responder that we want to take a look at. So let's start by talking about these taxing authority changes. There is a revision to Section 321.552 that allows EMS and fire districts to increase their sales tax up to 1%. And so previously that section authorized fire or EMS to impose a sales tax of up to 0.5%. This increases that authorization up to a full 1%. Of course, within that section, it's still accompanied by the rollback provision that rolls back property taxes by 1/2 of what you collect in sales tax. And so There's a calculation that you do every year. So if you're collecting the sales tax, it rolls back that property tax. Most districts, I think, that have the half cent in place have seen almost, if not a complete reduction in their property tax. And so that can be very appealing to voters, right? Because a lot of our voters, especially the ones who show up to vote, are the ones who own property in our district. And so they're going to see their property tax bill go down. And then we will also be collecting sales tax from people who are just traveling through our county or through our district. So if we've got a Walmart or a truck stop, a really great way, I think, to fund our services and lessen the burden on our property tax owners, we can now ask for that authorization up to a full percent. This revision also changed the restriction that prohibited certain counties from doing this. And so, for instance, St. Charles County, Greene County, Boone County, Jackson, and I think Platte County were the 5 counties that were previously prohibited from using this sales tax. This removes that restriction. So I anticipate that our friends at St. Charles County Ambulance will likely be soon looking at switching from a property tax to a sales tax if their voters approve it. And of course, fire districts, I think St. Charles is the only ambulance district in any one of those counties, but obviously there are fire districts in those other counties as well that can now go up to that 1%. There was a additional change in section 144-757, what we sometimes call the wayfare tax, a use tax. Missouri has this weird distinction between sales and use taxes that has some historic reasons, but I don't think makes as much sense anymore. But sales tax, of course, applies to the things that we walk into our local merchants and buy within our district. Use tax applies to things like internet sales or vehicles that we go and buy elsewhere and then we bring into our county. So you go to Kansas, you don't pay a sales tax there, but you bring it back, and when you register it here, you pay that use tax. Same thing for you buy something from Amazon. You don't necessarily pay a sales tax on it, but you may be paying a use tax. And so I want to point out, even if it says on your Amazon receipt that this is a sales tax in the state of Missouri, it's really a use tax. So not to be misled by that. But section 144-757 previously only allowed counties and cities to impose a use tax. That has been changed to allow any political subdivisions that provide emergency services. And it specifically references the statutes that authorize fire, EMS, and 911 agencies to impose their sales taxes can now authorize or seek voter approval to authorize a use tax as well. That use tax should be equal to the sales tax. And I think in almost all cases across the state it is, which just makes sense, right? Because the point of the use tax is so that there's not an incentive for your residents to go and buy from somewhere else. We want, if they're buying from Amazon, we want them to be paying the same sales tax or same tax rate that they would be paying if they went down to one of our downtown local merchants. And so that's really the idea behind the use tax. But I think the indication, kind of the calculations we've done other places, suggest that this use tax can be worth about 15% of your sales tax, sometimes a little bit higher, sometimes a little bit less. But so the opportunity to participate in that sales tax, especially for those ambulance or fire districts that have already switched to a sales tax, participate in the use tax, is really, really a great opportunity. If you don't have a sales tax already in place, or you're seeking to increase your sales tax, I am of the opinion that we can incorporate both authorizations into the same ballot language. And so if that's something your district is considering, we've had a half-cent sales tax for a long time. Now we want to go to a full cent. If you want to, and again, there may be some reasons to or not to do it. I think that you can incorporate that use tax ask into the same question and do it all at once. Unlike the provisions in our sales tax, however, I don't believe that there's any provision that takes that use tax and rolls back your property tax. And so where with the sales tax, you see a reduction in your property tax, I don't think that's going to happen with your use tax. There's no provision in 144 for that rollback. And so that's all just a new money. I would say there is some very specific language in this new amendment that we were successful in getting there that directs counties that may already be collecting a use tax based upon a sales tax. And in all the cases I've seen, it's based upon a 911 sales tax where the county is collecting the use tax, but has not been passing that on to the 911 agency. This makes it clear that they are to do that going forward. Unfortunately, it doesn't backdate anything, but says that going forward, you are to pay over that proportional share of the use tax that should be going to 911 because it's based upon the 911 sales tax. So I think very helpful for our 911 agencies that are in that boat. I know that there are some 911 agencies that the county commission, very forward thinking, very pro emergency services, has been paying that over to 911 for a long time. There are other counties that have not been doing that. So hopefully this will correct that issue. I don't want to speak too loudly, though, because, again, the governor has not signed this bill. And so certainly we don't want to raise the last minute ire of the Missouri Association of Counties and have some firestorm that keeps the governor from signing. So we'll just be quiet about that until he gets his signature on there, and then we can approach our county commissioners and point out the new law says they have to share the money that should have been 911's all along. There is a new section 190.073, that will require ambulance districts to obtain an audit once every 3 years. That's for all ambulance districts. It's not necessarily for ambulance services, but for districts, they have to obtain that audit. And the audit has to be done by a CPA or a CPA firm. So a financial review would not suffice. It does have to be an audit under the statute. I have been in touch with the Missouri Association of CPAs, and their local government committee sent me a list of about 20 auditors, I think, throughout the state that are recognized as doing local government audits. We sent letters out to all of them asking them if they were interested in offering their services to ambulance, fire, or 911 districts. And so I think thus far I've gotten a response back from about 6 or 7 of them saying that they were interested and they'd be happy to take on new clients. So we will have that list available. I know sometimes it's hard to find a CPA that does local government audits. So if you need that list, I'm sure we'll share it with MEMSA and MAA and Adam, and it will be out there for you just as a resource that we can reach out to those folks on. Let's see. I see, Will, where you raised your hand. Let me see. Do you have a question, Will? There you go. Can you talk now? I think I.
How about now?
Yep, I can hear you now.
Okay. I heard that we've had a real hard time trying to get an audit done. And what I didn't catch, what changed with the law?
So the audit requires now ambulance districts. There was no previous requirement for an audit. This requires ambulance districts to obtain an audit once every 3 years.
Okay.
I know one of the biggest problems we have is locating auditors. I'm not sure what your issue was with getting it done, but locating auditors that can do it, I think, was one of the biggest hangups I had seen.
That has been our problem. We can't find anyone. We can't find anyone to do an audit for us.
And so I'll have that list for you, Will. I know I've got 6 of them on there already that sent me their cards and contact information. And so I will pass that on to anybody who wants it. So you can reach out to them and get started with that discussion. Obviously, they're scattered all over the state, but for the most part, they're reviewing records. So we don't have to have somebody locally if there is no one local. And for instance, in my hometown, there's no one around here that does audits. I think I'd have to go to Jeff City to get anyone on the list, but I will certainly make that list available to you.
Okay, thank you.
All right, thank you, Will, for the question there. Okay, so I think that covers everything about audits. Again, if you have any other questions, don't don't hesitate to email me after we're done here. All right, I want to just mention the cardiac emergency response plans that are part of the new law that will require all public schools to develop and implement a cardiac emergency response plan for sudden cardiac arrests that occur at school. Obviously, something we want to be cognizant of. I think my indication, I was able to participate in the MOCAN Resuscitation Academy last week, and I think they said that just this past April, there were 2 sudden cardiac arrests at schools in St. Louis. And so something that we just want to be prepared for, and certainly we want to be ready to respond to in the event that that's needed. I think this is a great opportunity for our local emergency service agencies, fire, 911, and EMS, all play a role here to really partner and develop that relationship with our public schools. They have to develop a plan that establishes a response team, and that, of course, that team has to be trained in CPR. All coaches, school nurses, and athletic trainers have to be trained in CPR and AED use, and so a great opportunity for us to provide that training and get to go into our schools and meet with our teachers and students. Of course, there was already a requirement, right, for CPR training for graduating high school, a pretty minimal requirement just for 30 minutes of training, but it doesn't have to be certified training. And in fact, that training can be done by any first responders, including telecommunicators. So all of our high school students should have that 30 minutes of CPR training, but again, just the opportunity for us to go and interact with students and teachers in our schools. There's a provision for AED placement and maintenance. And so all of those AEDs through the schools are to be registered with the Missouri 911 Service Board. So we can make sure that information ends up in CAD systems, ends up at the hands of our dispatchers who can refer responders to where the locations those AEDs are at the school. And of course, if we're going to do our training, we're going to know that as well, but make sure that dispatch has that information available. There's a provision for annual drills, and of course, those drills should include fire, EMS, and 911, so that we're really rehearsing, going through how we're going to respond in the event of a sudden cardiac arrest, so that for those students and those at our schools that suffer from that, we can get those hands on chest as quickly as possible. We can initiate that bystander CPR. Get early CPR, early AED and defibrillation, and get those folks the help that they need as quickly as possible. So lots of opportunity for integration with our fire and EMS and 911 communities. I know that the Missouri Emergency Medical Services Association, MEMSA, received the state grant, I believe, to head up this effort to develop these programs. And so I know that MEMSA will be reaching out to our local service agencies, the districts, in order to help facilitate that. So I would encourage everybody to participate as much as possible. Some of the training changes for our ambulance districts. And so ambulance districts, unlike fire 911 centers, have some board member training requirements. Our board members have to complete an initial term or initial training that's usually about 8 hours. We've amended that statute, so there's now a continuing ed requirement where board members have to complete an additional 3 hours for each term of office. And of course, an ambulance district board member serves a 3-year term. So essentially 1 hour per year while you're in office. I think that there's a little bit of vagueness in the statute. So it talks about it being a 3-hour per term requirement. So I think there's a good argument that if you complete 3 hours during your term, that's all you have to do. It can all be in 1 year and you're done. But there's also a reference that continuing education has to be done on or before the anniversary date of your election, which of course an anniversary date comes around every year. So that would make me think maybe they were indicating it would be a 1 hour per year plan. I don't know. I think there's a good argument either way. Just to certainly be cognizant, we need to be making sure our board members get that additional continuing education. If they don't fulfill that continuing education requirement, of course, they they're disqualified from office and can't run for reelection. And I would point out this continuing ed requirement, the 1 hour per year, is essentially the same that school board members have to comply with, right? So there's school board members actually have to do 18 and a half hours of initial training. So we don't have quite that much, but there is a requirement for school boards also to do 1 hour of continuing ed. So that's pretty consistent there. There's a new section 190.112 that creates the position of an ambulance service administrator that will have to be identified to the Bureau for every ambulance service license. That service administrator has to fulfill 40 hours of initial training and then 2 hours of continuing ed training each year thereafter. That initial training is supposed to cover things like basic principles of accounting and economics, state and federal laws and regulations, human resources laws, grant writing, contracts, state sunshine law, volunteer community involvement, all of those things, to really ensure that our ambulance service administrators have kind of a base training. I know there's some discussion going on about what may qualify for that training. I think that there will be some opportunities probably this fall for some training. And there may be the opportunity also to have training you've already completed be approved as training. The training requirements for both of these categories actually, the training has to be offered by a statewide association such as MEMSA, MAA, or ADAM. And so, for instance, our board training is offered through the Missouri Ambulance Association, sometimes in partnership with MU, and then starting in June, MAA is having an independent program at their summer seminar, but it's provided by the statewide association, so it qualifies as the training. If it's not provided by a statewide association, that training then has to be approved by the State Advisory Council. And so if, for instance, you completed a bachelor's degree in paramedicine, obviously I would think that should probably qualify as your 40 hours of service administrator training. But that's going to be up to the State Advisory Council to say, yes, this qualifies, no, that doesn't qualify. Things like fire school, I think are all other great programs. Those just have to be approved by the State Advisory Council. And so I'm sure that they will have some discussions very soon once this law passes about what will qualify. Because for all ambulance service administrators that are in their position as of August 28th of this year, there is a deadline of January 1st, 2026. So you may realize that's less than 8 months away. There's a deadline to have this training completed. Again, I anticipate that there will be a couple training opportunities this fall offered. I don't have any firm details or nothing confirmed, but I think that there will be some opportunities for training if you don't have something that already qualifies or can be approved by SAC. But the deadline is technically January 1st of next year to have that completed. Along with this training, I'll talk more about that here in a few minutes, but there was some authority for the Bureau to determine qualifications for this ambulance service administrator position, but that is distinct from the training. So even if you meet the Bureau's qualifications, you still have to fulfill the training requirements. The Bureau has not set those qualifications yet, and so those will be set by regulation. Certainly, the process of regulation, they'll publish that regulation. Folks have the opportunity to comment on it. I don't know what those qualifications will be. Could be anything. And again, I'm not directing the Bureau one way or another, but maybe the Bureau will want to require you to be a paramedic. Maybe it will want to require a certain number of years in experience. The Bureau could require a minimum age, residency within your service area, all things that could be qualifications. I just want to point out those qualifications are distinct from the training. So kind of two different aspects there. All right, so then let's talk about the Public Safety Recruitment and Retention Act. Again, maybe the most exciting thing that we get to talk about today, that hopefully will help us in attracting and retaining folks in public safety. There's an entirely new provision in the law for this new act, and it applies to all public safety personnel. So we've included everybody in our emergency response family. It includes firefighters, EMTs and paramedics, telecommunicator first responders, and law enforcement. So we've got everybody in there. This provision will pay for tuition at an institution of higher learning. And that tuition is going to include all of those mandatory fees. And so obviously it includes the cost of the course, but if there's a computer fee or an activity fee, technology fees, all of those mandatory fees are included within tuition. Tuition does not include things like room and board, books, equipment, and supplies. And so those would still be left up to the individual. As I said, it applies to any institution of higher learning, which of course includes community colleges, state colleges, and universities. It may also include private institutions that choose to accept the tuition payments. And so I'll mention that a little bit later, but there's the possibility that private institutions could be included. And it includes any certified training entity that's certified by the Bureau. And so it could include coverage for obtaining a license or certificate as a paramedic, advanced training as a dispatcher, things like that. This funding is subject to appropriations, and so the General Assembly and the governor have to put money in the pot every year. But thus far, the governor's put $5 million in this year, so we do have a good start. It will pay up to 100% of the tuition costs for any public safety personnel that has at least 6 years of experience. And there are some additional qualifications there. You have to have a valid license as an EMT, medic, a certificate as a firefighter, post certification, 911 certification. You have to have some license that's been issued by the state or certificate that's been issued by the state. And you have to be employed full-time in public safety. And you have to remain full-time in public safety and remain a resident of Missouri during the course of your studies. Obviously, you have to meet the admission requirements of the university. This doesn't get you a free pass to automatically get into the school. And you cannot have previously had a baccalaureate degree. And so this is just for first-time degree seekers. You can't go back to use this to go back and get a second bachelor's degree or go back and get your master's degree. As I said, it allows you to pursue any license or certificate by a training entity. And it also allows you to pursue an associate or baccalaureate degree. Depending on the field that you're in, there are some limitations on what that degree can be about. And so you can see, I'm not going to read through them, but you can see if you're a police officer, there are some degrees that you can seek. If you're in fire or EMS, biology, paramedicine, fire management, communications are all options for degree programs. Both fire and EMS, because I guess, recognize that we have an increasing Hispanic population. And so anybody can get a degree in Spanish, and that would qualify. Advertising, public relations, communication sciences are also eligible for both fire and EMS. And then 911 telecommunicators can do any of the above. And so anything on the list for fire, anything on the list for EMS is eligible for a telecommunicator. As I said, you have to continue to remain employed in public safety and reside in Missouri during the course of that program. And you have to first apply for federal and state aid for financial assistance, the FAFSA and all that, to see if you qualify for different federal grants. If you do, we obviously want you to get your money from the federal government before you're taken out of the state pot. And so you have to make those applications. Once you have qualified, you can receive up to 5 years of tuition, 5 years or until you meet 120 hours of college credit, which is, of course, that's how many hours are in a baccalaureate degree. That eligibility, however, starts with your first receipt of the award. And so I would be cautious, if you get 1 year or you get 2 years in and then you decide to take some time off, I believe under the statute, your 5 years is still running. And so you want to be continuing to progress to that degree, because if you come back in year 6, I think you're no longer eligible. For dependents, I think, I don't know if I mentioned that before, but if you have 10 years of service, then your dependents will also qualify for this program. Dependents are not limited to the field that their parent is in, and so they can pursue any degree that's listed as an option. However, the dependents have to execute an agreement with the state to remain in the state of Missouri for 5 years after that degree is completed. And they have to prove by filing taxes in Missouri that they continue to reside in Missouri for 5 years. If they don't, if they leave after year 3, then all of that money that they received through this funding becomes a loan that they have to repay with interest, although the interest doesn't start accumulating until the end. But they have to pay that money back if they leave. So again, we want to make sure we're training these people, and then we want to get the benefit of them remaining in Missouri and using their education to benefit us in the state. That 5 years of residency begins, of course, at the completion of the degree, and so it doesn't. You can't be in school for 5 years, getting the tuition for 5 years, and say, "Well, I've been here for 5 years." Or if for some reason in year 3 you stop using it, it would begin at that point. But as long as you're receiving it, it starts at the end of when you last received it. The tuition, as I said, covers up to 100% of your tuition, or the grant covers up to 100% of your tuition after your federal or state aid. And it can cover the tuition at a private institution up to the equivalent of what would be paid to the highest combined cost of tuition and fees at a state university at the time. And so presumably the department says the department's going to do this, right? The department will review all of the state schools, find out who is the most expensive. If you want to go to a private institution, this grant would pay up to that amount, less what you receive from federal and state aid, to that private institution, on the condition that if the private institution accepts that, they can't charge you additional tuition. And so they can't say, well, there's a balance, right? In EMS, we call that balance billing. The institution can't do that. They have to basically accept that as a full ride scholarship. The application deadline for this is December 15th of each year, and then by March 1st, you're supposed to know whether or not you've received the award. As I said, the governor has put $5 million into the fund, or that's in the appropriation bill that the governor wanted. So we anticipate that he will sign that, and there'll be $5 million of funding for this year to get us started. But we probably recognize there may be a lot of people out there that are interested in this opportunity. If there are insufficient funds to award all of the applicants, there's priority given first to public safety personnel. So we're going to fund all of them before we fund any dependents. And then within public safety personnel, there's preference given to those that work within counties or cities that have the highest crime rates. And then if we get past those, to those with the most years of service. And so kind of the same breakdown once you get into dependents too, based upon where their parents work. But we're going to fund all the public safety personnel first under those 2 steps, and then fund all of the dependents. If there are equal numbers of people in a certain class, the money would be split equally between them, so that's kind of how that breakdown will happen. Again, hopefully this funding continues. That the governor and the General Assembly will have to appropriate funds into it every year to ensure that there's continued funding. But we have $5 million to start with. So a great opportunity, I think, for us to encourage our existing personnel to certainly pursue if they were interested in an associate's or even paramedic or bachelor's degree. All right, so then I want to talk a little bit about the new opportunities for what the statute refers to as corrective action, but I'd really like to think of as the opportunity for the Bureau to create dialogue among ambulance services that may have concerns. And so you may be aware several years ago, we had an ambulance district that was functioning one day and then the next day shut up their doors and essentially told the county commissioners, hey, here's the keys to the building, we're done. We want to make sure that that does not happen. First of all, because that really endangers patient care in that service area, but then also really taxes our neighboring services, right? And so if we're having to respond or mutual aid all of the time into a neighboring district, that taxes the ability of us to provide service in our own district. And so I don't like corrective action, but really I think this is just an opportunity for the Bureau to facilitate that dialogue to hopefully make sure that never happens again, right? And so the Bureau has the opportunity to refuse to issue, deny renewal, or suspend a ground ambulance service license or take other corrective action. So really the opportunity to just address this in some situations. One of those is if the district is financially insolvent, they're not able to pay their bills, they're on the verge of bankruptcy, the district can, or the Bureau can step in and start providing assistance. Inadequate staffing is indicated as one of the opportunities that the Bureau can begin this dialogue. And so we certainly want all of our ambulance services to have sufficient staff to meet their call volume. There is some language in the statute that says that every district should have at least one BLS crew, right, that's operating 24/7. We can't have an ambulance district that only has an ambulance Monday through Friday. That just doesn't work, right? And what we're going to end up with then is the neighboring agencies are covering the service area for 2 days out of the week, which is not fair to them. There should be a reasonable plan in place for a second ambulance unit when that first crew is out. But I think that can be accomplished through mutual aid. Of course, mutual aid requires a discussion with your neighbors, right, about how they're going to respond and maybe the opportunity for compensation. So, for instance, if you're running, and I don't think that there is anybody, thankfully, in Missouri doing that, but if you're running an ambulance service Monday through Friday and relying on mutual aid on Saturdays and Sundays, well, then probably your mutual aid partners, just out of fairness, should have some sort of financial compensation, right? Because their taxpayers are not really paying for them to cover your service area. And so just again, the opportunity to have that discussion. This statute doesn't impose any of that or require that, except in drastic situations, but the opportunity to begin those discussions. It does list inordinate amount of mutual aid. It sets that at 10% of the calls per month. So you may be thinking, wow, we have 50 calls a month. If we have 5 calls of mutual aid, then we've met that threshold. Again, I think the Bureau is going to be understanding in, that may be a one-time occurrence, something drastic happened, there was a natural disaster, a big event, something that caused that, but really wants to look at if that's an ongoing thing, if month after month, 10% of your calls are provided for by mutual aid, then I think there just needs to be a discussion about how we can help you make sure, help work with these agencies to make sure that we're increasing their staffing or what we can do to address that so that we're not relying on mutual aid just quite as much. There are some provisions for if your district administrator, your board members, other executives are for some reason criminally liable for the service you provided, ineligible to participate in Medicare, Medicaid, or Mo Health Net. Obviously, that would be significantly financially detrimental to your agency. And so if those are for some reason the case, you get somebody on your board that makes you ineligible to bill Medicare, that's going to be a huge problem, right? And so allows the Bureau to get involved in those discussions. And then our training requirements, I mentioned we distinguish ambulance service administrator qualifications from training, but your administrator is going to have to show they've met those qualifications and met that training. As part of renewing that license to the Bureau, I'm sure the Bureau is going to be checking up on that, require proof that your board members have completed their training. Because if you have 3 or more board members that fail to complete that training, then again, the Bureau can come in and initiate that discussion about what's going on, because really these training requirements are to make sure that we're just have a basic level of education, of shared knowledge and understanding among everybody. And so if that's not happening, we want to provide the opportunity for discussion. If the Bureau is determined that there's an insolvency or insufficiency, they're going to let you know. You have 15 days to submit a plan of action to correct it. That has to be then implemented within 30 days. And so what we're going to do to address that insufficiency. So again, it's really a dialogue. Not that they're going to come in and notify you, hey, your license is suspended today. It's going to be starting that discussion so we can address those concerns. That notice of determination is shared with the other services that are operating in your agents or in your area. So your neighboring agencies are going to be notified, because we want them to be involved in that discussion. We want to know how they can help you, or help this, or if you're the neighboring agency, how we can help the struggling agency. There's a provision to notify the members of the General Assembly. Hopefully they'll run back to Jefferson City and point out how we need more funding in EMS. Notify our county commission, the mayors, and then the regional and the state advisory committees, again, so that we can start pulling together a team to assist that agency that's in need of assistance, to make sure that they have what they need in order to succeed. That there is a provision for the Bureau to immediately engage in discussions with other service providers. So that if we have an ambulance district that collapses, the Bureau has the authority to go in and talk to those neighboring agencies to make sure to help facilitate that discussion to ensure we have coverage. In the event the service license is suspended, and so again, that's at the very end of this process, right? If that license is suspended, there is a new statutory provision that says if this district service license is suspended and their neighboring district has to come in and provide service, then that neighboring agency is entitled to reasonable compensation for doing that. Because of course it costs money to maintain an additional crew that's going to go over and cover this additional area. And that's coming at the cost of taxpayers that are outside of that service area. And so that there's a provision for cost sharing there, just to, again, make sure that we're doing things fairly, so that if we have to go in and cover something, that there's financial compensation. And hopefully it's a temporary coverage. Maybe then that local agency can go back to their taxpayers, get more funding, get better funding, figure out what they need to do to move forward. But we want to make sure it's fair to everyone involved. All right, there are some other miscellaneous changes, and I say that not because these are not important changes, but just because they didn't fit within any of the other categories I had. So there is a renewal for the line of duty death benefits for those public safety officers that are killed in the line of duty. There are a couple different versions in various bills. So it depends on which one the governor signs last. But hopefully he will sign House Bill 225 last, and that eliminates any sunset provision. So we won't have to worry about renewing that benefit again in the future. It increases that benefit from what is currently $25,000 to $100,000. And so for public safety officers that are killed in the line of duty, they would receive $100,000 from the state of Missouri. There is also a federal benefit, the public safety officer benefit. The current federal benefit is $448,575. And so if someone is killed in the line of duty, we definitely want to be cognizant of both of those benefits and make sure they get their applications in to get that funding for their families. It's not a change in the existing law, but I do want to point out there's a hierarchy of how that benefit gets paid out. And so it's first paid out, and that's under both the state and federal benefits. It's paid out first to a spouse, or if there are minor children, it goes 50-50 between the spouse and 50% to the minor children. If there is no spouse, then it goes in equal shares to the minor children. but the individuals have the opportunity to designate someone else after that to receive the benefit. If they don't designate it, it's going to go to their parent or to their adult children. But it's certainly possible that we'd have a single practitioner, a single public safety officer that's not married, doesn't have any adult children. Maybe both of their parents are deceased, but they're in a long time relationship with somebody. We want to make sure that person has designated who that benefit would be paid to. So just maybe something to include in your onboarding going forward. Give your new employees the opportunity to designate who their benefit would be paid to, because if they haven't designated, then that nobody's going to get the benefit, right? It just lapses. And there's obviously some significant financial benefit. We have people that are not necessarily married, but in long-time partnerships that just want to be cognizant of that. So consider that for onboarding. Unfortunately, the line of duty death benefit, both on the state level and the federal level, does not currently extend to 911 telecommunicators. So that's hopefully something that we can work on getting corrected in the future so that we can really cover all of our public safety community. At the moment, it only covers fire, police, probation and parole, EMTs, medics, and flight nurses. So just something to work on going forward. There was an amendment to section 191.227 to clarify. There was previously our first responder agencies, of course, collect a lot of health information. Both fire and 911 can get health information, health history from callers and patients. And that up to this point was not protected from disclosure and could have been requested under the Missouri Sunshine Law. So this amendment makes it clear that health information, that health history and treatment are not subject to disclosure under the Sunshine Law, and they are protected as health records in the same way that other records are. Of course, ambulance districts didn't have to worry about that because ambulance services are covered by HIPAA, but HIPAA does not extend to fire and 911 because they don't participate in Medicare billing. And so this amendment fixes that under state law to make that clarification. There's a new section 537.038 that extends that good law or Good Samaritan law coverage to all people who stop to render aid. Previously, it only applied to licensed personnel. And so this really makes the Good Samaritan law what we think it really should be, as we say, a Good Samaritan, because it covers everybody, not just licensed personnel that respond. And so anybody who responds, stops at the scene of an accident, attempts to render aid in good faith, has protection from civil liability under this new provision. And then there's section 574.204 creates the crime of interference with a first responder. And so specifically first responders that are on scene, if they give a verbal warning to somebody not to approach, so, stay back, we're taking care of the patient, don't come over here. And that person comes over there anyway and violates their scene, gets up in the middle of things. They come within 20 feet. They have committed this new crime of interference with the first responder. It is a first offense is a Class B misdemeanor and a second offense is a Class A misdemeanor. So certainly a good opportunity to have a discussion with our law enforcement partners, maybe talk with our local prosecuting attorney about this new crime that creates a disincentive to interfering with our first responders. There were some other changes that I didn't go over today. There was a change to the FRA provision in Missouri law to allow NU to qualify, and then some changes to the way the State Advisory Council on EMS is appointed. Not because I didn't think those weren't very important things as well, but just so that we didn't take up too much time today. There's my email. I think most people probably have my email and my cell phone number. If you have any questions, of course, you're always welcome to reach out. You can send me an email, call me, text me. I'm happy to do whatever I can to assist you and answer any of these questions. So with that, then I think that's kind of the end of the presentation. If anybody has any questions, I'm happy to answer any questions, but I thank everyone for attending today. There's a brief survey afterwards, mostly to just kind of highlight what you thought was important about this presentation. And it's my hope to continue offering these webinars about once every other month throughout the year. And so if you have any topics that you think would be of particular interest, please let me know that as well. So again, of course, thank you for your service to your communities, and thank you for joining us this morning.
Thanks, Frank.
Thank you, guys. Let's see. I do have, I'm sorry, I have a couple of questions I will answer real quick because I see that they're in my question and answer box. So if we don't have an administrator position, do the CE hours apply to our service? So under the provision for the ambulance service administrator, everybody will have to start identifying an administrator position. Now there's no requirement, I think, that necessarily be the person who has the sole authority for your district, or it's not like there's a job description given in the statute. There may be some qualifications that come out in the Bureau's regulations, but certainly I think I would keep an eye on those regulations. As I said, we want to make sure we're offering our comments to the Bureau, suggestions about how to improve those. But every ambulance service, and so there are about 220 service licenses in the state of Missouri, every ambulance service license holder will have to identify an administrator position. Is there anything to require you to stay working? I'm assuming that's during our public service position. Yes, you have to provide verification that you're still working full-time throughout those 5 years. I don't think there's anything that requires you to continue working in your public safety field for the public safety personnel after you've completed your degree. But as long as you're continuing to receive funding, you do have to continue to be working. So I think it probably is possible to retire within 5 years after completing your degree, if that was the question. So if nobody else has any questions, I think that answers everything I had in the question and answer box. So thank you again for everybody for coming, and we will see you next time.